The Finance Commission. The important role that has been assigned by the Constitution to the Finance Commission as a body entrusted with the difficult and delicate task of determining the share of the Union and the states in the taxes which have to be apportioned under both the mandatory and permissive provisions of the Constitution will be obvious from the preceding paragraphs of this chapter. The Finance Commission is an authority without parallel in other federations. In the field of center-state relations, it occupies a unique position, forming a vital link between the federal government and the regional governments, avoiding the stresses and strains which would otherwise have cropped up between them. Every finance commission has been flooded by the states with grievances of one sort or the other. It must be said to the credit of the Commission that it has dealt with each one of these grievances objectively and has suggested remedies and offered solutions for the most intricate problems. The confidence that the states have reposed in it is due entirely to its independence and impartiality and its ability to hold the scales even as between competing claims. Hence, it is that this committee has thought it fit to deal in this report with the composition and functions of the Commission. The Government of India Act 1935 did not provide for the setting up of any finance commission or any other similar body. The idea appears to have been first mooted by West Bengal in its memorandum to the Expert Committee on Financial Provisions. West Bengal emphasized the institution of a finance commission on the lines of the Commonwealth Grants Commission in Australia. One of the recommendations of the expert committee was that provision should be made in the Constitution for the appointment of a high-level tribunal to be styled the Finance Commission. The expert committee stated that ordinarily there may not be enough work for the Commission to keep it busy continuously, and that the members need not, therefore, devote their whole time to the work. According to the committee, the President, in his discretion, should appoint the members, and the reason given by the committee was that the Commission would have frequent occasions to deal with points of conflict between the centre and the units. The chairman was to be a sitting or retired High Court judge. On the other four members, the committee stated two should be selected from a panel of nominees of unit governments and two others from a panel of nominees of the central government. In the draft constitution prepared by the drafting committee in February 1948, Article 260 left it to Parliament to prescribe the qualifications necessary for the members of the Commission, including the chairman. The recommendation of the expert committee regarding representation of the units in the Finance Commission was not given effect to in the draft constitution. According to the expert committee, the Finance Commission should be a permanent body, the term of office of the members being limited to 5 years, subject to renewal. The expert committee also recommended that the Finance Commission should have the power to suggest variations in the heads of revenue assigned to the units, that is, the transfer of new heads or the withdrawal of existing heads, etc. It was further provided in the report of the expert committee that the recommendations of the Finance Commission, insofar as they do not involve any change in the Constitution, would be accepted by the President and be given effect to by him by order, while recommendations involving a change in the Constitution, if accepted by him, would be dealt with like any other proposed amendment to the Constitution. The draft Constitution did not embody these details in the article. When the draft Constitution was discussed in the Constituent Assembly early in November 1948, Tirutiti Krishnamachari expressed the feeling that the Finance Commission should be enabled to go into the entire financial structure of the country and recommend changes even in regard to the heads of taxation enumerated in the legislative lists. He also stated that the recommendations of the Finance Commission should be made binding on the Union and the states. When the provisions of Part 10 of the draft Constitution were discussed in the Assembly in August 1949, Thiru Krishnamachari, in the course of the discussions, stated that the Finance Commission was being set up with the limited object of assuring the states that they would have a fair deal and that the actual distribution should be done by the executive on the basis of the recommendations of the Finance Commission. In pursuance of Clause 2 of Article 280, Parliament has enacted the Finance Commission Miscellaneous Provisions Act 1951, Central Act 33 of 1951. The Act specifies the qualifications and disqualifications for membership of the Commission, term of office of the members, their conditions of service, and the powers of the Commission. It may be noticed from Article 280 and the Act of 1951 that no representation for the states has been provided for. It will be recalled that the Expert Committee on Financial Provisions expressly recommended that of the 5 members, 2 should be selected from a panel of nominees of the unit governments. It will also be seen that according to the expert committee, the members of the commission should be appointed by the president in his discretion. Under the constitution and statutory provisions mentioned above, the appointment of the chairman and the other members of the commission is being made by the Union Cabinet. We have already indicated that the independence and the impartiality of the commission have never been in question, and we think that the present arrangement regarding the appointment of the commission needs no change. Thiru K. Santhanam, in his paper referred to earlier, has suggested that the personnel of the commission should be settled after consulting the Interstate Council. This suggestion is worthy of consideration. The function of the Commission is specified in Clause 3 of Article 280. It is making recommendations to the President as to the distribution between the Union and the states of the net proceeds of taxes which are to be or may be divided between them, and the principles which should govern the grants and aid of the revenues of the states and any other matter referred to the Commission by the President in the interests of sound finance. The said Clause 3 deals with what has been called assured devolutions. As pointed out by the study team of the Administrative Reforms Commission, the shares of the states in the divisible taxes and the amounts of grants and aid under Article 275 are determined on the basis of a semi-judicial adjudgment by the Finance Commission. Under the Constitution, the recommendations of the Commission are not binding. Sri B. N. Rao, constitutional advisor, was of the view that although, as a matter of strict law, the President would be free to depart from them on the advice of the Cabinet, since the Commission was a quasi-arbitral body whose function was to do justice as between the states and the center, no ministry would advise the President to act otherwise than in accordance with the recommendations of the Commission. Again, Professor Alexandrovich, in his Constitutional Developments in India, has stated that though President should act only on the advice of his cabinet, in case of conflict between such advice and the advice tendered by the Finance Commission, the ministry could not ignore the recommendations of the Finance Commission in taking decisions. But under the Constitution as it stands, nothing prevents the Union Cabinet from modifying the recommendations of the Commission or rejecting them in toto. The recommendation of the Third Commission by a majority that grants under Article 275 should be of such amounts as would, together with surplus of tax devolution, cover 75% of the revenue portion of the plan outlay of the states was not accepted by the central government. We have already pointed out that the Expert Committee on Financial Provisions, set up by the President of the Constituent Assembly, stated that the recommendations of the Finance Commission should be binding on the parties. A similar view was expressed by Thiru T.T. Krishnamacharya also at one stage in the Constituent Assembly. Thiru K. Santhanam, in his paper mentioned above, has stated that the recommendations of the Finance Commission should be treated as an award so that there might be no opportunity for the center to discriminate among states on political considerations. The Finance Commissions have been functioning for a fairly long time, and it's desirable to expressly provide in the Constitution that their recommendations should be binding on all the parties, center as well as the states. All the answers received by the committee on this point support our suggestion. The work relating to the assessment of the needs of the states with reference to their tax efforts, economy in expenditure, and welfare activities calls for a continuous study of the problem. Any such study, if it is to be purposeful, should be undertaken by a standing commission of eminence assisted by a permanent secretariat. Data have to be collected from various sources, and a thorough scrutiny will be of considerable help in allocating funds to the states. The committee therefore recommends that the Finance Commission should be a permanent body with its own secretariat. The stature and importance of the Finance Commission have been considerably affected by the so called plan grants. Economic and social planning, is a matter specified in entry 20 of the concurrent list. There is no law relatable to this entry, although the executive power of the Union is coextensive with its legislative power. The power in relation to planning does not, in the absence of any express provision either in the Constitution or in any Act of Parliament, extend to the states. See the proviso to Article 73, Clause 1. With the establishment of the Planning Commission, the central government, on the advice of the Planning Commission, has assumed the responsibility for planning the state's development, even in spheres which are exclusively in the state field. Transfer of funds from the center to the states for purposes of planning has been effected in the form of discretionary grants and loans for implementation of the 5-year plans. Notwithstanding the constitutional position referred to above, the center has assumed the role of an overall planner for the states. As stated earlier, successive finance commissions have pointed out how the devolution of funds through the Planning Commission has curtailed the functioning of the Finance Commission. The third Finance Commission suggested a solution. It set out two alternatives. One was to enlarge the functions of the Finance Commission to embrace the total financial assistance to the states, whether by way of loans or devolution of revenues. This, the Third Commission stated, would be in harmony with the spirit of the express provisions of the Constitution. The second alternative suggested by the Commission was to transform the Planning Commission into the Finance Commission at the appropriate time. The study team of the Administrative Reforms Commission, which considered the interstate relationships, has, after examining various alternatives to avoid conflict between the Finance Commission and the Planning Commission, recommended that the Planning Commission should be entrusted with the entire work of determining budgetary needs, and that the Finance Commission should deal only with the sharing and distribution of central taxes, and the Planning Commission should determine plan assistance as well as non-plan grants. The Administrative Reforms Commission has, however, recommended that the Finance Commission should be asked to make recommendations on the principles which should govern the distribution of plan grants to states, and that the appointment of the Finance Commission should be so timed that when making its recommendations, it will have before it an outline of the 5-year plan prepared by the Planning Commission. Thiru K. Santanam is of the same opinion and has suggested that the Finance Commission should be asked to determine plan grants also for each quinquennium. See his paper referred to earlier. Thiru N.A. Balkiwala expressed the same view before this committee. In order to secure coordination between the Finance and Planning Commissions, the Administrative Reforms Commission has suggested the appointment of a member of the Planning Commission to the Finance Commission. The recommendation of the Administrative Reforms Commission seems to be the best solution, and we commend it for acceptance. This means that when constituting the Finance Commission, one of its members will have to be selected from among the members of the Planning Commission. We would suggest that the member of the Planning Commission to be appointed to the Finance Commission should not be a member of the central government, nor in any way connected with the central government. He should be a person who would command the confidence of the states. The Planning Commission is a body without any constitutional or statutory basis. It owes its existence to an executive order of the Union. Thiru Morarji Desai, speaking at the Indian Parliamentary Association Symposium on Center-State Relations held in New Delhi on the 3rd of May 1970, has dealt with the question whether the devolution of plan resources also should be regulated by statute. In that context, he has stated that it is true that in the earlier years there was not a regular system in this matter, and that sometimes favoritism was shown to some people according as the predilections of people lay. If the devolution of grants under Article 282 is channeled to the states through the Finance Commission, as suggested by the Administrative Reforms Commission, there will be no room for the complaint of the discrimination by the center. It's absolutely necessary that the distribution of funds and making of grants must be entrusted to an impartial body like the Finance Commission or any other commission consisting of non-party persons, and the Union government must accept its decision on such matters. The Finance Commission should be entrusted with determining both plan and non-plan grants for each 5-year period, and the central government should treat its recommendations as an award so that there will be no opportunity for the center to discriminate among the states on political considerations. Loans and indebtedness of states. While dealing with the finance, we cannot fail to take note of another connected topic, namely that of the mounting indebtedness of the states. The assistance given to the states by the center in the form of loans is much greater than the assistance given by way of grants, that is, all grants whether made on the basis of recommendations of the Finance Commission or otherwise. The bulk of the outstanding debt liabilities of the state governments is now accounted for by loans from the central government. The Administrative Reforms Commission, in its report on center-state relationships, has dealt with this problem also. It has recommended that loans for plan schemes should be given only when they are of a productive type. The question whether a scheme is productive or not being decided by the Planning Commission, in consultation with the finance and other central ministries concerned, and that assistance for non-productive capital schemes should be in the form of capital grants. It has suggested the reference to a committee of experts of the problem of dealing with outstanding central loans to the states for plan schemes, and also the question of setting up a sinking fund for the amortization of debts. The Fifth Finance Commission, which was requested to make recommendations as to the problem of unauthorized overdrafts of certain states with the Reserve Bank of India, and the procedure to be observed for avoiding such overdrafts as in paragraph 43 at page number 247 of the report suggested that the central government should consider the possibility of suitably modifying the procedure for consolidation of loans to the states so that their repayment may be in installments, which correspond generally with release of central funds to the states and the usual time of flotation of their market loans. The Finance Minister of Tamil Nadu, presenting the budget for the year 1970-71 on the 26th February 1970, told the Legislative Assembly that the state has suggested that the period of repayment of loans taken by the state from the centre should be readjusted to 20 to 25 years so as to be in alignment with the purposes for which they have been utilized. He has also reiterated that the time has come for the central government to appoint a federal debt commission to look into the entire question with a view to rationalize the pattern of lendings and of repayments. We may invite attention to the Australian Loan Council, which first came into existence in pursuance of an agreement between the Commonwealth of Australia and the states which constitute the Commonwealth by Section 105A of the Constitution Act and by laws enacted by the Commonwealth and the states. This agreement has been made binding on the Commonwealth and the states. The Council consists of the Prime Minister of the Commonwealth and the Premiers of states or their deputies. Each state has one vote, whereas the Commonwealth has two votes and a casting vote. The loan program of the Commonwealth and of each state is submitted to the Council in each year. If the Loan Council decides that the total amount of the programs cannot be borrowed at reasonable rates and conditions, it fixes the amount of the loan program. If the states and the Commonwealth do not, by anonymous resolution, agree on the portions of the amount to be allocated to each borrower, the amounts ought to be allocated according to a formula set out in the agreement and based on the borrowings of each state during the preceding 5 years. The problem of indebtedness of the states has put a heavy strain on the relationship between the centre and the states. We would urge that, as recommended by the Administrative Reforms Commission, a committee of experts may be set up to consider the whole issue, and we have no doubt that the committee will invite representations from the states and consider them in an objective and impartial manner. The committee to be set up for this purpose may also consider the desirability of constituting a body on the lines of the Australian Loan Council or forming a development bank on the lines of the World Bank to deal with applications made to the centre by the states for loans. Relief Fund. Whenever there is a convulsion of nature such as drought or floods, the present practice seems to be for individual states to apply to the state for succor. This practice has led to the criticism that the centre is discriminating as between the states. In order to avoid this situation, this committee considers that each state should constitute a fund earmarked for the relief of distress arising out of natural calamities. In this state, we have already a famine relief fund whose establishment and maintenance are regulated by statute, namely the Tamil Nadu Famine Relief Fund Act 1936, Tamil Nadu Act 16 of 1936. The Act specifically prohibits any expenditure from the fund except upon the relief of serious famine and the relief of distress caused by serious drought, flood, or other natural calamities. But it permits the utilization of any excess over 40 lakhs of rupees standing to the credit of the fund to meet the expenditure on protective irrigation works and other works for the prevention of famine. Apparently, other states also have a fund similar to the Famine Relief Fund in this state. If there is no such fund in any state, this committee recommends that steps must be taken to constitute one. The statutory provisions also may have to be amended to permit the utilization of the fund for ameliorative measures.